the new developments in the Karen Reed murder trial.
This has been a wild turn of events.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
It's a spectacle, that's for sure.
It was a hung jury, so no verdict, no real ending to this case.
Karen Reed was back in court where a date was set for her to be tried once again.
There are a lot of issues in this case.
Proctor was improperly searching Karen Reed's cell phone for nude photos.
Michael Proctor, the lead investigator,
relieved of his duties.
It's always the theories that each side will put forth for a jury to decide which one is more believable.
Karen Reed was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
Karen, did you ever say I hit him?
I did not.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
and once again, there was drama outside court.
There is a whole new set of legal troubles for Karen Reed. She is now facing a wrongful death lawsuit.
The lawsuit alleges that Karen Reed was drunk and reckless when she hit John O'Keefe.
It's not just Reed being sued here. The family also suing the two Canton bars from that night.
The two bars are liable for over-serving her.
The FBI is investigating an investigation of a murder. That never, ever happens.
At this point, multiple jurors have been reaching out to both sides, saying that they are certain Karen Reed is not a killer.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
There are 17 jurors, and they're coming and going with a police escort.
The investigation wasn't thorough.
This can't be good for the prosecution moving forward.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed!
I ended our last Conspiracy in Canton episode promising more information this week on Sandra Birchmore and Justin Root, along with any updates that may come up in the case against Karen Reed. I had everything planned out for this episode, but the last week and a half was a busy one in Canton. So I ended up having to rework this entire episode to get all of the new information in. There's a lot to cover, so I'm going to go through it so that you're up to date on all the newest information and where we stand, and then we will have to dive a little bit deeper in future episodes. There's a lot, y'all. First up, Judge Beverly Cannoni issued her ruling on the motion to dismiss from Karen Reed. Not surprisingly, she denied the motion. She stated that the double jeopardy does not apply here because the defendant was not acquitted on any charges, and she says that the defense counsel consented to the court's declaration of a mistrial. I'm not surprised that she denied to dismiss the charges. I knew that that was a reach, and the chances of that happening were slim to none. However, I have to admit that I'm disappointed that the judge denied interviews with the jurors. I think that it's important to find out if they're all in agreement that they reached a verdict, especially since multiple jurors have said that, and no jurors have come out to deny it. The ruling begins by going over the process of deliberations for the jury, and going over the notes that they sent down when they were deadlocked. Judge Cannoni says that the defense didn't argue against a mistrial in the moment, and that they pushed for the Tui Rodriguez instructions to be read when the jury mentioned being deadlocked on the charges. The judge did state on the decision that after she declared a mistrial, she didn't ask for counsel's arguments again at that time. She just dismissed the jury to go back to the deliberation room. Now, that is one of the issues that the defense listed in their argument. It's a little strange that the defense never got to see the jury's note, and there was no discussion about the note before the mistrial was declared. I think, looking back, it would have made more sense to read the note before the jury arrived back in the courtroom and have that discussion with counsel on both sides and clarify that they were deadlocked on the manslaughter charges, but hindsight is 20/20. Judge Cannoni also throws some shade at the defense when she says that they could have requested for the jury to be polled while they were still in the building, but she said that the defense proceeded to the courthouse steps where Attorney Jackson declared to the media and onlookers that the Commonwealth failed miserably and will continue to fail with its prosecution of the defendant. So, although Judge Canoni didn't ask if they had any objections or ask their stance on the mistrial, she says that the defense's actions afterward showed that they were approving of what happened at the time. She says that neither Jackson nor Yannetti have ever been shrinking violets, as in they've never been shy about speaking out when they wanted to be heard. The judge also goes over the jurors who reached out, documenting their texts and what all was said by jurors A, B, C, D, and E. The defense, of course, wanted to hear what the jurors had to say. The Commonwealth didn't. But the judge did say that she is taking the affidavits as true and accurate. However, that's not enough for her to do juror interviews. She's basically saying that even if they all come in here and say that they agree with what the other jurors said, that doesn't make it an acquittal since a verdict was not filled out on the verdict form, turned in, and read in open court. Judge Canoni sides with the Commonwealth again when it comes to the secrecy of jury deliberations. Instead of adopting the logic of the defense where they say that they aren't asking about the deliberation process, only about the verdict, she instead sides with the Commonwealth and says that the secrecy of jury deliberations has served as the bedrock of our judicial system, and inquiry into the deliberative process would intrude improperly into the jury's function. I've already said that this is something I disagree with. I'm not a lawyer, but I do know that, to me, the truth is the most important part of justice, and asking, hey, what was your verdict? Doesn't seem to be intruding on the secrecy of the jury deliberations. Overall, it seems that Judge Canoni puts most of the responsibility of the situation on the defense for failing to object to declaring a mistrial. Judge Canoni even said at one point that the defense advocated for that result twice, and then in a quote-unquote remarkable turnaround, now argue that it was sudden and unexpected. I think she makes her feelings about the defense pretty darn clear here. This is an unprecedented situation, but it seems like rather than use her discretion to forge a new path and create new precedent, she's deciding to just deny it and let the appellate court deal with it. And she's kind of making it pretty clear that she's not happy with how the defense has handled this. So what's next here? It is likely that Karen Reed's defense team will appeal this decision. However, it's going to be an uphill battle since this decision is made at the judge's discretion. So in order for an appeal to be successful, the appellate court would have to rule that Judge Canoni abused that discretion, and that's a really high standard. Also, the defense has already previously asked for Judge Canoni to recuse herself before the trial, but she refused. This time, it may open up the request for her to refuse herself again because the filing kind of shows bias against them if you read into her snark, which a lot of people have. She did throw some snark and some shade when talking specifically about Jackson and Yannetti, although she never once mentioned the distinguished attorney Martin Weinberg, who is the one who actually argued the motion at the hearing. Now, would trying again for recusal based on all of this work this time? Who knows? I doubt it. Only time will tell. There is also still a possibility that Lally decides to do the right thing and not retry Karen Reed on those 2 counts. But I wouldn't hold my breath for that one. It would seem to me that the right thing to do is to forget about those. I mean, why spend all of that extra time trying her for charges that were a stretch anyway? And if the judge says that she's accepting those affidavits as truth, prosecutors are supposed to be the ones who are pursuing justice. So wouldn't justice in this case be doing the right thing and not pursuing those charges? But I wouldn't count on that happening either, because the Norfolk County District Attorney's Office released a statement after the decision saying that they believe that the judge's decision is consistent with almost 200 years of case law. And they said that they're moving forward to trying this case on January 27th. The ruling from Judge Canoni isn't the only court filing that we have to discuss this week. John O'Keefe's brother, Paul, filed a civil suit against Karen Reed and C.F. McCarthy's and Waterfall Bar and Grill for wrongful death and negligent infliction of emotional distress. I had a feeling that the lawsuit against Karen Reed was coming, especially after the mistrial when Paul told Karen that he wasn't done with her yet. Now, the lawsuit against the bars comes a little bit more as a surprise based on the evidence that was presented in trial. It doesn't seem to make as much sense, and we'll get into that. The suit was filed Friday, August 23rd by Paul on behalf of his family and John O'Keefe's estate. So there are a few things to make note of here before we walk through each of the allegations. Number one, the burden of proof in a civil trial is different than it is in a criminal court. In order to be found guilty in the case of the Commonwealth versus Karen Reed, which is criminal, the jury had to find her guilty beyond a reasonable doubt. That's a high standard. And for good reason. This is someone's freedom that you're taking away if she's convicted. But in a civil suit, the burden of proof is just a preponderance of evidence, meaning it's just more likely than not that what is being alleged is true. So even if you're almost split 50-50 on whether or not there's guilt, if there's still a 49% chance in your mind that the defendant isn't guilty of the allegations, it doesn't matter. All it takes is 51%, just barely over that hump. That's all you need for a guilty verdict. The suit starts by listing the facts of the case. Now, the first four list out Paul and then John's mom and dad and then John's niece as the plaintiffs. The next three list C.F. McCarthy's and then Waterfall and then Karen Reed as the defendants. The next facts explain that John O'Keefe was the middle of three children in a tight-knit family, and he was a third-generation Boston police officer. After the tragic deaths of his sister and her husband, he took custody and guardianship of his niece and nephew and spent the next 8 years raising and supporting them until his passing, at which point John's mother took guardianship and custody of the children. So, the first 11 facts listed in the suit are pretty undisputed. Some of the statements listed as facts that come after that are not so clear-cut, and there will be a lot of litigation going into arguing some of this stuff. For example, what's listed as fact number 12 is that in the months, weeks, and days leading up to January 29th, 2022, Karen and John's relationship was deteriorating, and during that time, Karen picked fights, experienced jealousy, and had delusions of unfaithfulness. Number 13 is that she knew that their relationship had run its course, and those aren't things that can really be listed as facts when they're open to interpretation. It seems a little off to put what you think that someone felt or thought or knew as fact, especially when the evidence presented at trial can suggest otherwise. So, example of this, they have listed as a fact that Karen picked fights, but if you look at the entire text thread that was entered into evidence, it showed that it was actually John who had picked a fight that morning, and Karen expressed how hurt she was by that, and he did apologize. Another example is the jealousy and delusions of unfaithfulness. The text between Karen and John showed John expressing jealousy that day about the plumber that was coming to look at Karen's hot water heater. He even made some type of remark about how he hopes that the plumber is hot. Now, as far as knowing that the relationship had run its course, there was testimony from the Colakethis that Karen was gushing over her feelings about John and that she was excited about a trip that they were planning together in the near future. So, based on that, it doesn't sound like this was at an end. The next group of facts has the times that specific things happen. So, all of the times that the bartender handed Karen a clear liquid drink, the times that she arrived, the times that she left, when John left, etc. Now, most of these things will be undisputed. However, they have it listed as a fact that at all relevant times that Karen was at these bars, she was showing signs of intoxication. That is not going to be an accepted fact by any of the three defendants. especially since there was so much testimony stating that Karen did not appear intoxicated, and we don't see any signs of intoxication in the surveillance videos that we saw during trial. The next group of facts state that Karen was under the influence of alcohol and unable to drive safely, and that she drove John to 34 Fairview. It's listed as a fact that Karen and John were in an argument that night, and then it went into the early morning of January 29th. This will also more than likely be disputed as fact, I'm sure, since they are clearly not in an argument the night of the 28th. We see them the entire time hugging and kissing and laughing. Everyone who testified said that there was no tension, no arguing. And Mr. Kohler-Keithis even made a joke about how his wife commented to him that she wished that he was as lovey-dovey and affectionate with her as John and Karen were.
You didn't see any body language between the two of them that would suggest an argument or a fight or tension?
In fact, I noticed the opposite.
Describe that.
They were affectionate toward each other, loving toward each other, and to the point where my wife even made a comment, why are you not like that with me?
You had something to live up to.
Yes.
They didn't leave the bar until after midnight, so it's easy to prove that this particular fact isn't an actual fact. The next set of facts will all be highly disputed. It says that after John got out of Karen's car, she drove her SUV and hit him, knocked him onto the ground in front of 34 Fairview, causing serious injury and resulting in his death. Then she fled, returning to John's house. It says that she knew that it was snowing and that there was an impending blizzard, and that she knew or should have known that leaving John outside would likely result in serious injury or death. It goes on to say that she failed to use any care to avoid creating an unreasonable risk or harm to the public and to John, and that she took obvious risk knowing that death or serious injury was reasonably predictable, then persisted in a clearly negligent course of conduct over a noticeable period of time, was impatient with reasonable precautions, deliberately inattentive to the hazards of her actions, and or was deliberately inattentive when there was risk of great and immediate danger. Now, all of this is going to go back to whether or not they believe that Karen actually hit John with the car. The documents say that Karen was reckless, and her conduct made it highly likely that John would suffer serious injury or die, and she knew but chose to ignore the risk, which resulted in John's death. The next set of listed facts state that Karen woke up around 4:30 a.m. She knew that she had hit John, but chose to wake up his niece, who she knew was a vulnerable minor that had already lost her parents tragically and was now dependent on John as her surrogate parent, talking about John's death and involving her in frantic phone calls about it. It says that Karen knew that John was on the ground at Fairview where she had left him to die hours earlier, and that she admitted repeatedly that she had hit him. This admission will be contested since there are disagreements about who actually heard her say something like this, what was said, and of course the fact that if she had admitted this in front of officers like they're alleging, the entire morning would have played out a lot differently because they wouldn't have just let her go. So the documents say that Karen went to John's house, feigned comfort to his family, then used the opportunity to remove the offending weapon, which was her vehicle, and or destroy relevant evidence. It also says that her blood was drawn and the retrograde extrapolation gave the range that would have been above the legal limit to drive in Massachusetts. Finally, the list of facts accuse Karen of knowingly and deliberately changing her story when speaking publicly, fabricating a conspiracy that she knew to be false, and publicly communicating this false narrative, causing the plaintiff's aggravated emotional distress. Now we're going to get into the actual allegations and each count, right after this. This show is sponsored by BetterHelp. Can you think of something that you really want to learn? As an adult, do you make time to learn new things the way that you'd like to? Or was that something that was lost somewhere along the way after childhood? Kids are always learning new things, expanding their minds. But as adults, we sometimes tend to lose that curiosity. So what's something that you'd like to learn? A new language? How to cook? Or maybe how to finally beat your best friend at pool? Therapy can help you reconnect with your sense of wonder, because back to school era can come at any age. Therapy isn't just for those who have experienced major trauma. It's helpful in so many ways. Learning positive coping skills, how to set boundaries, how to set and achieve your goals. It empowers you to be the best version of yourself. If you've heard everyone else talking about how much therapy has helped them and you've been curious to give it a try, check out BetterHelp. It's entirely online, designed to be convenient, flexible, and suited to your schedule. Just fill out a brief questionnaire to get matched with a licensed therapist, and switch therapist at any time for no additional charge. Rediscover your curiosity with BetterHelp. Visit betterhelp.com/juror today to get 10% off your first month. That's BetterHelp, HELP.com/juror. In the civil suit filed by the O'Keefes against Karen Reed, C.F. McCarthy's, and Waterfall Bar and Grill, there are a total of 13 counts. The first 3 are for wrongful death. They are the estate of John O'Keefe versus C.F. McCarthy's, then Waterfall, then Karen Reed. The next 3 are all for negligent infliction of emotional distress against C.F. McCarthy's. One for John's mom, one for John's dad, and one for John's brother Paul. The next 3 are same charge, same members, but they're against Waterfall. And then the next 3 after that, same charge, same family members against Karen. And the final count is against Karen for negligent, reckless, and or intentional infliction of emotional distress, specifically against John's niece, Kaylee. So I know that that's a lot of counts, but it's really all going to boil down to just a few things. So let's break it down. The first 3 counts are the wrongful death counts. So what is wrongful death? In Massachusetts, a wrongful death is a death caused by negligence, a willful, wanton, or reckless act, or breach of warranty. So, in other words, a wrongful death claim comes when one person dies due to the legal fault of another person or entity, including negligence-based incidents, such as a car accident, an intentional act, which could include a crime, or medical malpractice. Now, this can be filed in any situation where the deceased person could have filed a personal injury lawsuit if they had survived. As in other types of personal injury lawsuits, a successful wrongful death case, the defendant's liability is expressed solely in terms of financial compensation or damages that the court orders the defendant to pay to the deceased person's survivors or estate. So basically, there's no jail time involved, it's just money. The next 9 counts are all negligent infliction of emotional distress, or NIED. Look, there is no doubt in my mind that these 4 family members have suffered emotional distress. I have said over and over that I can't imagine the stress that they have faced, the sense of loss, the pain. No parent should have to bury a child, and these parents had to bury 2. Paul lost both of his siblings so tragically. Kaylee lost both of her parents, then her uncle who raised her for the next 8 years. The amount of loss and suffering that they have experienced, it's incomprehensible, and it's heartbreaking. Under Massachusetts law, NIED claims are much more specific than just acknowledging that emotional distress that a person goes through. According to the law, NIED is a claim in response to one party acting recklessly or negligently that results in significant mental or emotional injury to another party. So there are specific criteria under the law that qualify an action as NIED. which entitles a victim or a person with a close personal relationship to the victim to compensation. So in order for an NIED claim to qualify, they give distinct and separate elements that a plaintiff is required to prove. So number one, you have to prove that the defendant was negligent. That means that they have to establish that a duty to use reasonable care exists. That duty was breached. Breaching that duty was a substantial and contributing cause of the accident and the injuries. And because of that, the plaintiff is entitled to compensation for the injuries. Second, a plaintiff must show that they suffered some sort of emotional distress as a result of the misconduct. Third, the plaintiff's emotional distress must have caused some kind of physical harm. Now, that means that John's parents, brother, and niece will all be forced to prove that they are each having physical symptoms or harm that are a direct result of the emotional distress that they have faced. Fourth, a reasonable person standard applies in the analysis of whether there was physical harm. What that means is that a reasonable person in the same circumstance would have also suffered emotional distress. And then the fifth element is the emotional distress must have been directly caused by the defendant's negligence. I know that that's a lot, but in an oversimplified Cliff's Notes version, they have to show that Karen, C.F. McCarthy's, and Waterfall all each had a legal duty to exercise care that they disregarded, which then caused an accident, which then caused emotional distress, which then led to physical harm in each of them. Now, the last count that involves John's niece is the only one that's a little bit different, since it involves reckless and or intentional infliction of emotional distress, which it's directly related to Karen's actions when she woke up that morning and she woke up Kaylee in a panic. There's a lot of information that came out during the trial that will more than likely be used as this civil case progresses. So first, let's take a look at C.F. McCarthy's. Count 1 claims that C.F. McCarthy's negligently served alcohol to an intoxicated person, namely Karen Reed. It says that they knew or should have known that she was intoxicated, and serving her violated Massachusetts dram laws, safety policies, showed gross negligence, and wanton and reckless disregard for the safety of others. They say that C.F. McCarthy's persisted in serving Karen alcohol well after they knew that she was visibly intoxicated, and as a result of their negligence, Officer John O'Keefe sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial expenses, and died. Also, as a direct result of their negligence, John's next of kin suffered and are entitled to damages, and they demand judgment against C.F. McCarthy's for compensation, punitive damages, lost value, plus costs, and any other relief that the court deems appropriate. So, what this one really boils down to is whether or not C.F. McCarthy's was negligent in serving Karen Reed alcohol. Now, this is a bar, so of course they're going to serve alcohol, but the negligence comes in if they knowingly overserve a drunk person. And in order to prove that, there has to be evidence that the bartender knew or should have known that the customer was intoxicated when they were served their last drink. For things like this, they usually want to bring in witnesses that testify to the person slurring their speech, stumbling, having glassy eyes, smelling of alcohol, etc. So what do the witnesses that were there say about Karen Reed? Well, not that. On day 7 of the trial, John's friends, Mike Camerano and Kurt Roberts, both took the stand. Now, they were present at C.F. McCarthy's that night, and they spent some time with John and then with Karen when she arrived. Mike and John were the first there and then sent Kurt some messages, kind of teasing him and making him come. Now, he said that he couldn't let those teasing messages happen, so he showed up and was there for about an hour and then slipped out, Irish goodbye style, without telling anyone that he was leaving. Mike said that he left just a few minutes later. Both men testified to seeing Karen with a clear liquid drink, but said that there was nothing out of the ordinary, no fighting, no overly drunk behavior. So, without witnesses saying that, what else could they rely on? They will surely review the bar tabs, right? Mike Camerano said that he picked up the tab when he left. So we don't actually really know what's on it at this point. He wasn't asked during trial, and he didn't mention it being out of the ordinary. They show surveillance video of Karen being handed clear drinks while at the bar, but we aren't shown if she finishes them or not, and we aren't shown what receipts prove that they are. Many bars will have training or serving requirements for their bartenders that go beyond obvious signs of intoxication. It could be like counting drinks or measuring the alcohol. But if all of the drinks were on the same tab, that could present another problem, because how do you differentiate between that many people drinking on one tab? But even with the burden of proof being so much lower, this one still may be difficult to prove. But if that one seems hard to prove, the ones against Waterfall will be even harder. Count 2 is the estate of John O'Keefe versus the Waterfall Bar and Grill for wrongful death. So the same allegations apply, but the reason that this one will be even harder is because not only were they there for less time, but there are more witnesses saying that Karen was not visibly intoxicated, and there were fewer drinks served. Having so many witnesses saying that she wasn't visibly intoxicated when she got to Waterfall will probably help out C.F. McCarthy's to prove that she wasn't visibly intoxicated there either, since, of course, she was there before she went to Waterfall. Now, John's bar tab at Waterfall was for one Bud Light bottle, which he drank, one Miller Lite that was bought for Chris Albert, and one Tito's drink. But the bartender did say that she did not notice John buying drinks for a woman. The total was only $16.58, and the bartender on duty, Rebecca, has been bartending in Canton for 11 years, and she testified that nobody seemed overly served or highly intoxicated.
You didn't notice John buying drinks for a woman that night, did you?
No.
And with regard to your sort of scanning the people that were there within that group, one of your duties as a bartender is to make sure that nobody's overserved, right?
Correct.
And so, while you don't watch every movement all the time, you do look for signs that somebody might be overserved, correct?
Correct.
And with regard to the group that came in, the receipts for which you were shown today, nobody really seemed highly intoxicated to you, correct?
No.
So the bartender didn't notice anyone seemingly intoxicated. And you have testimony from Mike Camerano, Kurt Roberts, Nick Kolakithis, Karina Kolakithis, Chris Albert, Julie Albert, Nicole Albert, Brian Albert, Matt McCabe, Jen McCabe, and Brian Higgins, that everything seemed fine. She did not appear drunk. That's a total of 12 witnesses saying that Karen Reed was not visibly intoxicated, plus video surveillance of her seemingly acting normal, talking, laughing, having conversations, direct conversations with people who said she was not visibly intoxicated. If that many people are saying that she was fine, plus there's video surveillance where she appears fine, it's going to be really hard to prove otherwise. If they can prove that Karen ordered and consumed a bunch of drinks at C.F. McCarthy's, they may have a chance there, but the documents say that Karen had one shot and one mixed drink from 10:54 p.m. to 11:54 p.m. while at Waterfall. And serving 2 drinks in a 1-hour time frame to someone who showed no signs of intoxication based on that many witness statements and an experienced bartender, that's going to be hard to prove. There was one other drink, but she walked in with that one. Here's Chris Albert.
When they first came over, the defendant came in with a glass underneath her jacket, and I thought that was kind of funny, and I laughed about it and made a comment about it. It's a tall, like, cylinder glass with some clear liquid in it and a lime.
And that was under her coat when she came?
Yeah, it was like she pulled it out.
Plus, the people who saw Karen drinking could only say that she was drinking clear liquid. They weren't sure what was in the glass. Here's Nicholas Kolakithis.
She was holding a cup, a glass with a clear liquid. I don't know what was in there. I don't know if it was water or alcoholic drink, but I don't know for sure.
That's all for the wrongful death. But there are 6 counts of negligent infliction of emotional distress against the 2 bars as well. The documents say that seeing John in the hospital after he was found caused each of the family members to suffer severe and profound emotional injuries that manifested in physical symptoms. It says that each of the bar's negligence is what caused John to be there, which makes them legally responsible. Now remember, with the NEID claims, they have to establish that the bars had a duty, which is usually a given. It's part of Massachusetts law. And they have to prove that they breached that duty, which caused the injuries and death of John O'Keefe. Now, this will again go back to whether or not they served Karen Reed when they shouldn't have. Then they will have to prove that the emotional distress has caused physical pain or symptoms of some sort. So that covers the counts against the bars, 4 against Waterfall and 4 against C.F. McCarthy's. Now let's look at Karen's, starting with the wrongful death. In this claim, the documents state that Karen owed John and the public a duty not to drive drunk, to drive with due care, and to pay attention to the roadway. It says that she breached her duty to John by driving drunk, which caused John's injuries and death. The main points here that they will need to prove are that she was drunk and she hit John with her car, both of which have been disputed by defense. Now, remember, the burden of proof is much less in civil cases, so time will tell what happens here, but it may get ugly. Driving drunk, it's definitely a problem. In fact, according to the National Highway Traffic Safety Administration, about 37 people die each day in the United States in a drunk driving crash. That's 1 every 39 minutes. And on average, those who drive drunk will do so about 80 times before being caught. The drunk driving part of this has brought up a lot of conversation about a few things. Number 1, the amount of intoxicated driving that has been mentioned involving this case or the witnesses. For example, everyone discussing drinking at the bar and then going to Brian Albert's to drink some more and then driving home. Then, of course, there's the witness testimony about former trooper Michael Proctor and Kevin Albert, where they were investigating a cold case and apparently driving around drunk in the patrol car. So drunk that Kevin misplaced his badge and gun. Then there are the previous DUI incidents and car crashes from witnesses in this case. One being Chris Albert. Now, I mentioned in episode 26 that Chris Albert was involved in a hit and run that resulted in a 23-year-old MBA honors college student losing his life. Chris was charged with leaving the scene of an accident causing death and motor vehicular homicide by reckless operation. While it was never proven in a court that Chris was intoxicated, it's been widely speculated on because the accident occurred at 3 a.m., but Chris Albert waited about 30 hours before finally turning himself in. Another one that has been widely discussed is the 2020 OUI of John's brother Paul. Now, I have purposefully chosen not to report anything about this because Paul is the victim's brother. And his mistakes, whether they were from 4 years ago or 4 days ago, don't change the fact that he is the victim's brother. And it doesn't change what he's gone through with this and the loss of his brother. But I do see that there has been a lot of backlash against the civil suit, which has in turn led to this incident being brought up and shared on multiple platforms, often with wrong information. So I'm going to relay the information about this one according to the police report and the fire department and the court docket. But I want to clarify, this incident doesn't make Paul's loss any less valid. So on October 11th, 2020, Lakeville Police Department responded to a crash involving 2 cars in front of Joe's gas station on Route 18. 73-year-old Carl Prather was traveling south on Bedford in a minivan, and Paul was northbound and turned left into the gas station, right in front of Mr. Prather, failing to yield to oncoming traffic that had the right-of-way, which caused Mr. Prather to crash into the passenger side of Paul's car. It ran him off the road, and Mr. Prather crashed through a large electronic gas station sign before his van came to a halt. Now, there are photos that were taken by the fire department of the scene, and there was extensive damage to Mr. Prather's car, as well as to the front passenger side of Paul's. And the sign in front of the store was destroyed. Now, responders said that Mr. Prather appeared to be in excruciating pain. He complained of neck pain, loss of feeling in his extremities. It was pretty bad. He was transported to Good Samaritan with internal chest trauma, head trauma, neck trauma, and trauma to his collarbone. The fire department was dispatched, and since the scene was pretty tore up, a recall was transmitted, bringing in off-duty firefighters to work the crash scene. Officer Andrew Cedarquist wrote in his report that Paul spoke in a slurred and confused manner, and he detected a moderate odor of alcohol on him. He listed out the other visible signs of intoxication, and Paul was apparently wavering side to side and seemed to be struggling to keep his balance. He had bloodshot, glassy eyes and seemed to have a slow, delayed movement when he was blinking. He had apparently been golfing, and Officer Cedarquist asked him to do some field sobriety assessments, which he agreed to, though apparently he seemed confused when the officer instructed him on where to go to get out of the way of the debris to do all of this. He wasn't really able to follow along with any of the officer's instructions, and his confusion and slurred speech were noted multiple times on the report. He was arrested and taken into Lakeville Police Department. He refused the breathalyzer test, and he was charged with negligent operation of a motor vehicle, operating under the influence of liquor and serious injury and neglect, and failure to yield to the right-of-way. He pled not guilty, and a trial date was set, but was canceled and then pushed out and then canceled again. The entire process drug out for quite a while, and in the summer of 2022, Paul was given 1 year of probation for the only charge that stuck, which was the negligent operation of a motor vehicle charge. His probation is shown to have been terminated after completion last year. So, when it comes to the civil trial bringing up the drinking and driving, yes, it has stirred up a lot of debate on the ethical implications or the optics of that. But I imagine that no matter how many of us think that we know how we would behave in a certain situation or what we would do if it were us, grief and loss and emotion and anger are all driving forces that can make human behavior, even our own, unpredictable. And in those moments, I think that it's good to show some grace. So while I do understand the argument behind this specific aspect of the very spirited debates, I'd rather leave that one where it is and move on to the next topic. So let's talk about the last aspect of the suit, the emotional distress allegations against Karen. Now, part of it is the same as in the NIED against the bars. The family said that when they saw John in the hospital, they were witnessing what they allege are the consequences of Karen's negligence, which caused severe and profound emotional injuries that then manifested in physical symptoms. But there's also an additional and very interesting aspect to this one. The NIED claims against Karen say that she, quote, outrageously created a false narrative, end quote. Now, I mentioned at the beginning that one of the statements listed as fact said that notwithstanding her Fifth Amendment right not to speak, Karen chose to speak publicly. It says that she knowingly and deliberately changed her story and fabricated a conspiracy that she knew was false, and then publicly communicated this false narrative. So this is interesting to me for multiple reasons. First, because this is something that Paul also accused Karen of during his post-trial interviews.
It's stories, lies, innocent people's lives being ruined. I understand a aggressive defense strategy, but this is above and beyond anything ethical.
The second thing that's so interesting about this to me is that Paul says that this fabricated story started with her attorneys. He said basically it was when Alan Jackson was brought on the team.
Remember her first arraignment in Stoughton District Court?
Yeah.
Her attorney, David Unetti, had said this is a tragic accident. Fast forward to, I guess, when Alan Jackson came on board. A lot of the public was misinformed, because they were only getting one side of the story. And, we didn't come out and tell our side of the story or, what we thought or knew happened. We've kept a low profile and have been silent through this whole ordeal. Now it's time. Now it's time for people to understand the truth.
Paul said that he believes that Karen hit John in a fit of jealous anger. He said that as soon as Karen left John's house after they got back from the hospital, that's when he knew. But he said that his mom had already asked him before that if Karen had something to do with it. And we also heard in testimony during the trial that as soon as John's mom was called and told that Karen dropped him off at a party, she made some sort of comment wanting to know why Karen would have left him there. But thinking that someone is creating a false narrative and suing them in court for it are two different things. So let's take a look at Paul's allegation against Karen. That arraignment for manslaughter charge was in February of 2022, and David Unetti was Karen's attorney at the time, but Alan Jackson had not yet joined the team. Here's David Unetti.
I think that there was a lot of political pressure on this district attorney's office to bring charges in light of the fact that a police officer was the victim here.
So he says that he feels like there was pressure from the district attorney's office to bring charges, but he maintains his client's innocence on the courthouse stairs to the media. Now, the only part of this clip that seems to be played and circulated is the part where David Unetti says, "My client had no criminal intent. She loved this man." I've even played that clip on the intro in previous episodes. However, that's not the full clip. Unetti doesn't say that this was a tragic accident and Karen hit him on accident and she's upset. He actually specifically says that he's not going to speak to what happened that day, but he maintains that his client is innocent and that it will come out at trial. But that part never gets played. Here's that clip.
It's a defensible case. I will tell you that my client has no criminal intent. She loved this man. She is devastated at what happened, and she is innocent, and that will come out at trial. I'm not going to speak to what happened on the day in question. I'm just going to tell you that my client is not guilty.
I know, the audio on the full clip is terrible and probably hard to hear. So I wanted to play it unedited so that you can hear it, but I also cleaned it up as much as I could to try to isolate his voice so that you can actually understand him. Here's that.
I will tell you that this is a defensible case. I will tell you that my client has no criminal intent. She loved this man. She is devastated at what happened, and she is innocent, and that will come out at trial. I'm not going to speak to what happened on the day in question. I'm just going to tell you that my client is not guilty.
Here's why I think this matters so much. This entire clip, from start to finish, of Unetti on the courthouse steps is right at 2 minutes. Now, that is from the time that he says and spells his name for the media until the time that he says that he's not giving any more statements, and he confirms that Karen will be back in court on March 1st, and then he turns and walks away. That entire clip, 2 minutes. Not once during those 2 minutes does Unetti say that Karen Reed accidentally hit John or that it was a tragic accident. He says it's a defensible case, that there's no criminal intent, which refers to the charge of manslaughter that requires criminal intent. And he said that she loved this man, that she's devastated at what happened, and that she's innocent. Now, the reference to no criminal intent directly follows Yannetti's comment about how there are political pressures to charge Karen with manslaughter. So when he says there's no criminal intent, it's referencing his comment about the DA's office charging her with a crime that he says she doesn't meet the standard for. The way that people have edited these statements, it's misleading. And it doesn't help that major news organizations repeat it. Gretchen Voss mentioned the courthouse steps statements in her article for Boston Globe, saying that Yannetti told reporters outside the courthouse that his client was in shock and that O'Keefe's death had been an innocent accident. But that's not what he said. He said his client is innocent, not that it was an innocent accident. When you have a full 2-minute video that's really difficult to find, and then you have an article that misstates what's said in that video circulating everywhere, it's no wonder that Paul and so many others believe that that's what he said out there. On the way home from that arraignment, attorney David Yannetti says that he returned a phone call to a man that had called his office about this case. Now, what was said in the tip varies depending on who you hear it from and when, but Yannetti told Boston Magazine that this man told him that Karen was innocent and that Brian Albert and his nephew, which would have been Colin, and a federal agent, Higgins, were the ones who were responsible. There was allegedly an altercation, and then John didn't come to, so they put his body on the lawn at Fairview. I decided to leave the man's name out of this because he did not want to be brought into it, and he was trying to help, and he's had a lot of unwanted attention since then, so I'm going to keep his name under wraps in this episode. Now, he used to work with Brian Albert years ago. He's known him for a long time, but they aren't close friends. But Yannetti says that that phone call on that day in February after Karen's arraignment is when everything changed. They went from not having a clear understanding of what happened or what could have happened to piecing together information and details. They hired a private investigator who was able to then uncover that Colin, who was left off of all of the police reports, was actually present that night. He was at 34 Fairview. When Karen heard this, she said that she immediately remembered some incidents between John and Colin that caused friction between them. Now, other pieces began to come together for them. So seeing the injuries on John's arm and believing that they looked like dog scratches, and then finding out that Proctor had a close relationship with the Alberts, including ties to Colin since he was a child, but somehow he was still the lead investigator on this. All of this started coming together piece by piece. 3 months after those courthouse comments, in May of 2022, David Yannetti appeared in court, fighting to get cell phone data from Google that could show who was in the area when John O'Keefe was killed. Lally was there as well, of course, arguing against the defense being given this preservation order.
What is the DA's office afraid of? It's just my asking the court to order the DA's office to make sure that this evidence is preserved.
My concern, and it's certainly nothing that I'm afraid of, my concern is that it almost seems as positive as the defense is essentially trying to direct Commonwealth's investigation. I don't find that any of this information is particularly relevant, and it's not something that I would be pursuing this type of case.
The following month, the Norfolk County District Attorney's Office increased Karen's charges from manslaughter to second-degree murder. And she was arrested again, facing a new arraignment for the new upgraded charges. Body-worn camera captured her comments to officers at the police barracks as she told them that it was Brian and Colin Albert who were responsible for this. Attorney Alan Jackson wasn't contacted by Karen Reed until after this. He actually officially joined her defense team in September of 2022. They began filing motions requesting data information from Brian Albert and others, speaking out about the issues that they were seeing with the case, and working on developing their defense strategy as new evidence was being introduced, all to help prove their client's innocence. About 7 months after Jackson joined them, Aidan Carney, aka Turtle Boy, wrote his first article about the case. He included social media posts showing connections between the Alberts, the McCabe's, and Proctor, and the document with the now infamous Google search of how long to die in the cold. The rest, as they say, is history. The tipster wanted to be left out of everything. After all, he had a connection to some of the key players. A report that was done by Sergeant Yuri Buchanan claimed that the tipster didn't say that he had personal knowledge of what happened, only that he gave the tip that he thought that John had been beat up. Now, that is on Buchanan's report. And with his internal affairs investigation, along with the numerous other reports that he did that were said to be inaccurate and proven to be inaccurate in this case, you can take that for what you will. Not often does a defense attorney have more credibility in a murder case than one of the main investigators, but yet here we are. So, the allegation that Karen Reed's defense said that it was a tragic accident, and then Karen changed the story by fabricating an outrageous narrative when attorney Alan Jackson joined the team, and then they worked with Turtle Boy to spread that narrative. That actually doesn't line up with how things happened. And it may be hard to say that she fabricated a narrative when the defense's theory is based on a tip, plus cell phone data, plus the amount of police misconduct surrounding it. Everything basically supported this theory. That will be an interesting one to follow to see how that plays out. The final aspect of the civil filing is the negligent, reckless, and/or intentional infliction of emotional distress that relates to Karen Reed and John's niece. Now, the documents list her vulnerability due to the passing of her parents and then her Uncle John. And it says that Karen woke her up at 4:30 a.m. and had speakerphone conversations to various people during the next 30 minutes, which caused his niece to hear Karen say things like maybe a snowplow hit him or maybe she hit him, etc. They said that this caused his niece to perceive the injuries and the injury-producing event. It goes on to say that after waking her up and informing her that something had happened to her uncle, Karen then left, which left her home alone. The documents list this behavior as extreme and outrageous and beyond the bounds of decency and utterly intolerable. So, how can the civil trial impact the criminal trial? This civil suit has the potential to either help or hurt both sides when it comes to the criminal trial. The suit opens up broader avenues of discovery that weren't available during the criminal trial. There are stricter guidelines in a criminal case about what evidence is allowed against a witness or defendant. But with a civil suit, the door can be opened to bring things in that weren't available before. So this could mean more evidence that they could potentially try to use against Karen, or if Karen wants to prove what she said about the Alberts being responsible for John O'Keefe's death, then that could also potentially open up some different avenues to bring in discovery that wasn't allowed before as far as that goes. Also, if Karen does a deposition under oath for the civil suit, anything that's said can also be used against her in the next criminal trial. She can, of course, plead the fifth, though it's hard to predict for sure how that would impact the civil trial. Also, Paul's testimony may be affected. Testifying in a criminal trial when you have a lawsuit filed against the defendant would be kind of tricky. After all, he would stand to benefit financially if Karen is found guilty, which shows bias in his testimony. And that presents complications if they put him on the stand again. Now, another interesting aspect of this is that insurance often includes a clause that has a duty to defend. This means that the insurance company can be required to defend the policyholder against lawsuits that may be covered by the policy. Now, that doesn't mean that all of a sudden her insurance company is going to be cutting big checks to Jackson and Yannetti. If she does have this coverage clause, then it's usually the insurance companies that decide which lawyers to hire and whether or not to settle or whether or not to take it to court. Now, in situations where there are some allegations that are covered and some aren't, In this case, let's say if the wrongful death being potentially covered, but the emotional distress is not being covered, the insurance company still has a duty to defend the entire claim anyway. So this could potentially open up some resources for Karen's defense. The bars that are listed on the suit will also have insurance, and it's often those types of lawsuits that can end in the big payouts. Going after a business that has liquor liability insurance is more than likely going to pay out a lot more than going after an individual. If they end up settling, or if the bar is found guilty, it could mean a big payout to the O'Keefes, as well as the bar potentially having any number of repercussions, like stricter guidelines from the insurance company, or fines, or additional training requirements, or even loss of their liquor license. Wonder where Canton would go if these two spots had to close down. I guess there's always D&E Pizza. Maybe they can get a liquor license. Anyway, of course the bars and their insurance companies don't want to see this happen. So they will fight to prove that Karen Read was not visibly intoxicated, nor was she overserved while at each of these establishments. So anything that's brought out as proof of that only benefits the defense. There have been a lot of questions also about why they would file this suit now, before the next trial has even happened. I did a little bit of digging, and I was looking at Massachusetts law, and it seems like there is a statute of limitations in Massachusetts for 3 years to be able to file this lawsuit. So, since that's coming up, then Paul and the family would have had to have filed this suit before January 29th. The next trial is set for January 27th, so it wouldn't be possible to wait until after the next trial anyway. All right, there are 2 other topics that we need to quickly cover. First, there was another juror interview done. Aidan Carney was able to ask some questions to one of the jurors who wished to stay anonymous and wasn't comfortable answering every question, but did agree to give some answers and some insight into their perspective on the case. The full article that Carney wrote on this juror can be found on his website, and he posted the link on his social media page. But I wanted to go over a few of the answers that were really interesting. First, the question was asked if the jury was able to see the protesters assembling outside the court. Apparently there were times that they could hear them or catch a glimpse of the bus, but they couldn't see everything going on outside. The juror was also asked about Judge Canoni. Here is that response. Quote, "She was kind to us. She always made a point to remind us to stand up and stretch during sidebars. She kept to the schedule for breaks and lunch like clockwork, and she reminded everyone to keep their voices up so we could leave the AC on. It got hot in the jury box. Sitting in a chair listening to testimony all day is different from real life. You need to be attentive and catch everything. And you can't just get up and move around whenever you want to. It sounds pretty silly unless you experience it, but it's very different when you can't just get up to go get a snack, use the bathroom, take a brain break, or get some air anytime you want. Of course, when we asked for breaks, there was never any pushback, but we were also cognizant of the need to keep things moving. At times, I did feel there was a level of professionalism that wasn't being maintained and that the severity of the circumstances was not always at the forefront. It bothered me when there was an objection and her response was, 'I'll let them have it.' I think there was some bias against the defense, particularly Mr. Jackson. But I also think there were times she was hard on Mr. Lally, particularly when it came to repeating questions about well-established things that already made clear throughout prior testimony. There were times I would glance over and wonder if she was paying attention, but to some extent, I can understand that it was hard to stay focused. I struggled with this myself, mainly if it was something we have already seen or heard 8 times, like the weather report, or the layout of the waterfall bar, etc." End quote. I know that one was a long one, but something that has come up a lot about Judge Canoni is her bias and how she is perceived. So there were some good things in there and some bad things, so I wanted to read that entire answer verbatim. The next one. The juror also said that the 2 witnesses from Aruba, which would have been the Sullivan sisters, felt like the most pointless witnesses. However, the most unnecessary, he says, or she says, were John's niece and nephew. They didn't see any reason to bring the kids in after everything that they had been through, and it felt wrong to have them on the stand with everyone watching. Another very interesting perspective, Carney asked about Brian Albert, Brian Higgins, and Michael Proctor greeting the jury and thanking them after their testimony. The juror responded that these three men were a huge focal point of the trial, so the juror said they wished that they could have taken it as nothing more than a polite gesture, but that's not how it was taken. The juror also felt that it was inappropriate to have Brian Albert, Colin Albert, and Jen McCabe in the courtroom for closing arguments. They also questioned Brian Albert not coming outside that morning, especially since first responder instincts are ingrained into responders and they become part of who they are. And something felt off about Jen McCabe because of how combative she was and her constant request to see her previous statements before answering. The juror felt the same way about Proctor that so many of us did, disappointed to hear the text where he, quote-unquote, dehumanized Karen. The juror felt like Colin was very elusive and didn't believe the story about hurting his knuckles by slipping on the ice and catching himself on his knuckles. I don't think that anyone believed that story. They also mentioned Allie McCabe's testimony about Colin being in the house, saying that she slipped up and said that Colin wasn't in the house when John was there, and pointing out that the Commonwealth said that he wasn't there at all. Now, the juror also was asked if they felt deceived by the inverted Sallyport video. The response, quote, yes, very much so. The prosecution's emphasis on this video and its supposed significance in proving beyond a reasonable doubt that nobody was near the damaged taillight was a primary focus throughout the trial. It was a shock to find out that what I believed I was seeing and what I was actually seeing were not one and the same, end quote. That was a big one. They also didn't know about the federal investigation, and finding out about it later made them feel misled and hindered their ability to see the whole picture. The ARCA experts were not known to be hired by the feds or the Department of Justice, so it turns out that the jurors just thought that they had just maybe read about the case and decided to analyze what happened. Being hired by the FBI never even crossed their mind. For the full list of questions and answers in Carney's article with this juror, you can go to his website, tvdailynews.com. So, our final topic of the day, which we are going to get much deeper into in the next episode and future episodes. The arrest of Matthew Farwell. Y'all, I was live on camera when I got this news, and I could not help but to cry. It was an emotional day and a huge step forward for seeking justice for Sandra Birchmore. I've mentioned Sandra's heartbreaking death in previous episodes. She was 23 years old and pregnant when she was found dead in her apartment in Canton. Farwell was a Stoughton police officer who met Sandra when she was only 13 years old and took part in an explorers program with local police. She was a child who was groomed and then sexually exploited by Farwell, who was 27 years old the first time that he committed statutory rape against Sandra, taking her virginity when she was only 15 years old, just 1 month before he married his wife. For a decade, Sandra survived grooming, statutory rape, and sexual violence, all at the hands of Farwell, who committed these acts while on duty, falsifying reports of his hours to conceal what he had done. Farwell continued an affair with Sandra after she became an adult, though after years of coercive control, I can't bring myself to call it consensual, even if she was finally of age. Sandra told Farwell that she wanted a child of her own, and told him that she wanted him to impregnate her in exchange for her silence about the child sexual abuse and the years-long affair. 2 months later, Sandra was pregnant, and though Farwell had said that he wasn't going to put his name on the birth certificate or be involved, Sandra told them that she wanted him to be more involved. Between her pregnancy and wanting him to be a part of the baby's life, and word starting to spread about their sexual relationship, Farwell started to feel like he was losing control. His wife was also pregnant at the time, due around the same time that Sandra was. In January of 2021, one of Sandra's friends called the Stoughton Police Department and reported the sexual relationship between Sandra and Farwell. When Farwell found out, he was mad. He told them, "Don't ever talk about this again." He was furious, and he told his friends that he had become physically violent with Sandra about this, even putting the pregnant girl in a headlock, telling her that he wished that she were dead. 2 weeks after that call, Farwell entered Sandra's building with his hood up, wearing a COVID-type mask and keeping his head down from the camera. He can be seen getting on the elevator, then coming back down and exiting the building about 27 minutes later. A federal indictment says that Farwell went up to Sandra's apartment, strangled her to death with a duffel bag strap. Then, using his knowledge and experience as a law enforcement officer, he staged it to look like a suicide. Farwell lied repeatedly to state police detectives investigating Sandra's death. He denied their sexual relationship, and then he lied about the time frames, trying to distance himself from her pregnancy to avoid suspicion about being the father of her baby. Before her death, Farwell also told Sandra to delete evidence of their sexual relationship off of her phone, trying to cover his tracks to prevent being caught. He faces a minimum sentence of life in prison, but it's a federal charge and it's also eligible for the death penalty, but no decisions have been made yet about whether or not they're going to pursue it. This is a huge step for justice for Sandra Birchmore. And in the coming weeks, we're going to continue to dive deeper into the details of her case. And like I've mentioned before, you'll continue to hear a lot of the same names. Both of these cases happened in Canton. The Norfolk District Attorney Michael Morrissey's office is the same one prosecuting Karen Reed, and they're the ones that were responsible for the investigation into Sandra's murder, though it was ruled a suicide and Morrissey publicly stated that there was no evidence of criminality. He also publicly stated that there was no evidence of criminality with anyone in the Karen Reed case other than Karen. I guess whatever he decides, he just tells the public that that's it. And anything else that they may think or they may see, it's false. They both involve off-duty police officers, accused of misconduct and murder. There is corruption involved in both cases. Both cases involve police investigating deaths, and with other police tied to it, there were things that weren't done properly or thoroughly. State Trooper Nicholas Gorino did an investigation into Sandra Birchmore's phone and said it produced 0 messages between Birchmore and Farwell. But investigators later found almost 33,000 text messages between them during the last 14 months that she was alive. Gorino, who didn't find anything, is also the state trooper who testified in Karen Reed's case. And just like he didn't find any of the deleted information in Farwell's phone, he also said he didn't find any of the deleted information that was in Jim McCabe's phone. A medical examiner made a ruling on Sandra that was questionable, and another medical examiner disagreed with it. Years later, it was proven to be wrong. A medical examiner made a ruling on John O'Keefe's death that was questioned, and another medical examiner disagreed with that as well. Canton police officer Michael Lank was the first to go in the house at Fairview, and he was one of the first ones on scene at Sandra's apartment as well. Trooper Matthew Dunn was told about Farwell's suspicious behavior after he found out that Sandra was pregnant, but nothing happened with Farwell. Trooper Dunn is also the one who handled the missing library footage in Karen Reed's case. Lieutenant Fanning was also told about Farwell acting really weird after Sandra's pregnancy. You've heard that name before too. Fanning is Proctor's boss, the same one who was on that group text. Kevin Albert, Brian and Chris Albert's brother, was also involved in the investigation of Sandra's death. All of these parallels. The feds stepping in on 2 death investigations in the same small town, both involving police corruption, both involving the DA making public statements about how there's nothing going on here. Proctor, suspended. Buchanan, internal investigation. Tully, internal investigation. Kevin Albert, suspended. Gorino, missing evidence, not found in both cases. Lank, among the first on scene in both cases. Medical examiner's rulings questioned. Police corruption. sweeping things under the rug, lying to the police and to the public. Are you listening yet? You can no longer tell us that covering up a murder can't happen. You can no longer tell us that these cops won't cover up for each other. You can no longer tell us that it's too crazy and there's no way that it could happen. At what point do people stop looking for reasons why this can't be something that happened and start realizing it wouldn't be the first time? Paul O'Keefe said in that interview that U.S. Attorney Josh Levy never should have got involved in the investigation into John's death. He said that he intervened himself and casted a shadow of doubt onto the investigation. But is that what they said about him involving himself in the investigation into Sandra's death? Think about how much information came from both of those federal investigations, thanks to Josh Levy intervening. If there's an opportunity or some avenue that can open doors to resources that can get help to get to the truth, whatever that truth may be, there's no reason to keep that door closed. Hearing about Sandra, I was emotional and excited and hopeful about Farwell's arrest. And I'm hoping for more arrests to follow. There's a lot more to this case that we will be discussing soon, and some of the players that are involved are also involved in the investigation into Justin Root's death. We're also going to talk about him in coming episodes. We're far from done. There's a lot more to talk about in Canton, Massachusetts. My name is Brandi Churchwell, creator of 13th Juror podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.